This is Office Talk with Annette Stepanian. Hey there, welcome to another episode of Office Talk. I'm really excited about today's interview because we're diving into a topic that I get so many questions about. It's about what you need to do when you hire your first employee. Scary, right? If you're just starting out, maybe you're thinking, that seems like so far away. I can't even imagine having my own employee. But if you've been in business for a while, or maybe you're starting your business and you thought, hey, I need an employee from day one, it is quite a maze to try and figure out what you need to do. So in today's episode, I'm joined by Jenny Wiegley of the Maier Law Group here in California, and we're going to dive into a conversation about what smart business owners need to be thinking about before they hire their first employee. Now, if you need a little extra support in navigating, hiring, training, and managing your employees and contractors, then I want you to check out a limited time bundle that Michelle Loretta of Sage Wedding Pros and I have put together. It's called Your Team Toolkit, and you can find that over at bit.ly/Your Team Toolkit. Or you can always head on over to my website, yourlegalbff.com, and you can find the links there. Now, what is Your Team Toolkit? Well, it's everything we think you need to hire, manage, and train your team. And the special bundle savings of $100 off makes this a no-brainer. What it includes is Michelle's People Plan, which is a 64-page book and 25 templates that are going to help you navigate everything you need to hire and train and manage your employees and contractors. It covers things like preparing to hire, hiring a superstar, training your team, interviewing, finding an employee, managing, all that good stuff. She's also included her employee handbook. So the employee handbook is something that you can use when you start hiring, and it helps define your policies and procedures of your company, things like vacation and time off policy, workplace expectations, all that good stuff. And finally, the bundle includes my done-for-you independent contractor template. So if you're hiring independent contractors as opposed to employees to assist in your business, then this contract template is for you. So I encourage you to check it out because this bundle is only available through January 31st of 2018. And as I mentioned, it's $100 off what you would normally spend if you were going to buy all three of these individually. And you can find that over at bit.ly/Your Team Toolkit, or you can just head on over to yourlegalbff.com. Okay, that was a mouthful. Now with that said, let's go to the show. Hey, Jenny, thank you so much for taking the time out of your busy schedule to be with us today.
Well, thank you so much for having me.
So before we dive in, I always love to bring our listeners up to speed about who you are, what you do. I know you're a fancy schmancy lawyer, but maybe you could enlighten us about what kind of law you practice currently.
Sure. Well, I don't know about fancy schmancy because I tend to work in my pajamas.
Love that.
Yeah. I work remotely when I'm not at a client site, which is amazing. But I'm an employment lawyer, and I've been an employment lawyer my entire career, which is about a decade long. I was interested in employment laws and labor laws by the beginning of law school. And I think for me, it was because those are where the juicy issues and facts are. It's kind of like the soap opera of law, but not the level of family law, which seemed too intense for me.
Yeah.
That has been true. You know, it's been just juicy enough without kind of keeping me awake at night, usually. And so I've always represented companies. I've always been on the defense side. And I used to get flack from that from some of my friends, like that I was representing the man or the bad guy. But in truth, you know, in almost a decade of practice, my clients have never been the bad guy. Sometimes they've made a mistake because they didn't know what to do. Sometimes it's just a total misunderstanding between employer and employee. Sometimes an employee is just, they have their own agenda and they're looking for a payday. There are a lot of different reasons that stuff goes down, but, you know, employers generally really do want to do the right thing, and they come to employment lawyers like me for help doing the right thing. And that's really rewarding to me. I love representing employers and working with businesses, and I've really specialized in tech and startup companies since I moved up here to the Valley 3 years ago.
Yeah. And I want to just touch upon something is the folks that I work with and I interact with, like, I would say almost all of them that I've been in touch with is they really want to do the right thing. Like they're not here to shortchange or to do anything illegal. It's just the law can be so confusing. It can be so overwhelming, especially in the area of labor and employment. And so that's why I wanted to have you on here today, because I wanted to talk to you about when someone is ready to hire their first employee, right? So they've done the whole analysis. They're like, okay, this person's not an independent contractor. The folks who listen to this show hopefully are pretty savvy on the difference between the two. But if not, make sure to check out some of the past episodes on this topic. But like really, where they're here, they're ready, they're committed, they want to hire their first employee. And then they're like, I don't know what that next step looks like for me. So can you just start shedding light and kind of walking through us maybe like a checklist of things that a small business owner needs to be thinking about when they're ready to hire their first team member?
Absolutely. Yeah. And you're right. I mean, these laws, they're very interconnected. California in particular is at this time the most difficult place to be an employer in the country. And just because of all of the various requirements, and it can be really overwhelming. But people need not fear. It's not as bad as it seems. And there are really only a handful of things that you have to do. And so if you understand those things, I think you're going to be starting out from a really good place. And as your business grows, you will be prepared to kind of evolve your practices. But if you're just starting out and it's just you and you don't have any employees at all, the first thing you have to do is basically become an employer for tax purposes with the federal and the state government. So you're going to go to the IRS. The very first thing you're going to do is go to the IRS and get your employer identification number, or EIN is the abbreviation for it. And that's where everything begins when you become an employer. And it's a pretty simple process. Do it online nowadays. Pretty much everything you need to do can be done online nowadays, which I think makes it a lot easier.
Yeah. And so the EIN, it's free. And it's basically like a social security number for your business, right? Is that how you describe it? Okay.
Yeah. It's the tax ID for your business for purposes of you being an employer. And California has its own entity that's like the IRS called the Employment Development Department. I'll call it the EDD from here on in, which is how it refers to itself. And the EDD does a lot of different things. But one of the things it does is similar to the IRS and the EIN number, you can get a California employment number. So you just go online to the EDD's website once you have your EIN. So that's kind of like the first step. Once you have that, you then go on to the EDD's website and you register as an employer. And they have a few different forms that you fill out. And then you're set up with both the federal and the state government to be an employer. And like you said, you're not spending any money at this point. You're not even necessarily committing to hire anyone. You're just laying the groundwork so that you actually can hire.
Okay, that's easy peasy. Got it.
Easy, yeah. And one of the things you want to do probably before you hire anyone is purchase a workers' compensation insurance policy. The law requires that you have one, and it's not super expensive. There are definitely ways to get bargains for smaller businesses. You just have to shop around and find a good policy. And just make sure that whatever policy you have is going to cover each person that you bring in. So every time you bring someone in, check against your policy, make sure they're covered. I think that a lot of times people are hesitant to have employees versus contractors because of the requirements like workers' comp, but there really just aren't that many requirements. They're not that onerous. And, once you kind of face up and start doing it, you realize it's not that big of a deal. It's kind of like any other insurance policy you'd have. I mean, you have insurance on your car and your house, and, maybe you have it on a piece of jewelry that you own. And now you're just having it on your employees so that if they get hurt in the scope of their work for you, that's covered by the insurance and it doesn't end up coming out of your pocket for the most part.
Now, I have a question, and I hate to interrupt your train of thought, but this could be something we revisit later, but a lot of folks that I work with people who work remotely. So they don't necessarily have a storefront or an office where people come in. They might be working with an assistant, a virtual assistant or something, who lives in a different state. So as to the issue of workers' comp, do you still need workers' comp if you don't have a physical location where your workers are coming to?
You do, because
Okay.
they could still be hurt in the scope of their work, right? If they're working remotely and they're on a computer all day, they could develop carpal tunnel.
Okay. Get a paper cut. Okay.
Yeah, they could be out taking something to the post office to mail you a form for work and they get into an accident.
Okay.
There are a lot of different things that could happen, and it's just a legal requirement. So if you kind of take the risk-benefit analysis out of it and just think of it as, this is a box I have to check.
Yeah.
You know, and it's not as scary as it seems.
It's a cost of doing business, right? So
Exactly.
you just got to get that insurance. Okay, cool. Thanks for that clarification.
Of course. And that actually, your question kind of dovetails with the next thing I was going to talk about, which is workplace postings. I know that almost all of us have worked in an environment where it's a big office, and when you go to the copy room or the break room or whatever, you see that big poster about your rights under federal law. It has the minimum wage posted, whatever. The reason that you see those posters is because both federal and state law mandate that employers put certain posters up, and they have to be refreshed as they get updated. Now, what do you do if you don't actually have a physical office? How do you have workplace postings? You know, obviously you don't need to go out and buy the posters if you don't have a space to put them in, but you do have to make sure that you get all of that information to your employees anyway.
So could that be something that you send out as part of like the offer package and have them sign off on it to agree that they've received it? Or what do you recommend people do there?
Yeah, exactly. You can just, you can download a lot of these required postings for free. California in particular provides free downloads on the EDD website for all of these postings. And you can easily just Google, like, what postings do I need in my industry or whatever? Because there are some postings that you only have to have if you work in an industrial setting. And there's some postings that you only need if your business is in the city of Oakland. It really varies. So there's no way to know exactly which postings you need unless you kind of do a little bit of research or ask an employment lawyer. That's a question they can answer pretty quickly. But whatever is required, getting it into a form that you can just email to your employee or work into your employee handbook that you'll be giving the employee, then you'll be covered on those grounds.
Okay, that seems like pretty doable. I think most of us can figure that out, right?
Yeah, I think the only hard part is figuring out which postings you need. And when I say hard, I mean you can figure it out in half an hour.
Now, let's say you're based in Oakland, right? The employer is based in Oakland and the employee, let's stay in California, right? They're within the same state. The employee is in Los Angeles. Do you have to then provide the Oakland postings if there are any kind of unique ones, or the one where the employee is located?
So I hate to be a total lawyer, but it depends. Because it depends on what the posting is about. Sometimes there are certain laws that apply to any employee of the business, regardless of where they're located, if the employer itself is located in that city. And then there are some that apply to any employees in that city, regardless of where the employer is located. An example is San Francisco's new paid family leave law. That applies to any employee who works in the city of San Francisco, regardless of where their employer is. So if their employer is in Nebraska and they work remotely from their house in San Francisco, they're covered by that law. Mm-hmm. But there are other laws that only apply if the employer is based in the city. So, it's a little bit of a complicated question, but it's not anything to worry about at the outset because a lot of these things only apply to employers of a certain size.
Okay.
And so if you're just talking about the really basic things for a brand new company, it's going to be pretty limited. Yeah, and not too complicated. It'll only get complicated as you grow. And I think as you grow, you're getting more HR and legal expertise thrown at you.
And what is that number generally? Or again, does it depend? Is it if you have more than 50 employees, the rules start to change? Is it more than 10? Do you have any kind of sense of that? Or it, again, depends?
Totally depends on the law.
Okay.
California's Fair Employment and Housing Act, which is kind of like our civil rights law, that kicks in at 5 employees. The Pregnancy Disability Leave law also kicks in at 5. But Family and Medical Leave Act and the California Family Rights Act, they kick in at higher numbers. FMLA kicks in at 50. California Family Rights Act kicks in at 50, but now as of January 1st, 2018, it's going to kick in at 20 for purposes of baby bonding leave. So and organ donor leave, that kicks in at 15. And so really it's all across the board. But when you're under 10 employees, there are very, very few that apply.
Okay. I think most people can handle that because most of the folks in the audience are probably, like I said, one-woman shops. Maybe they have 2 to 5 employees, if that. So, okay. So don't freak out, you guys.
Yeah, do not freak out. Just keep it on your radar that as you grow, different laws are going to apply to you, and you may have obligations to inform your employees about those laws, but you don't always.
Okay.
So, yeah, maybe I went too far there, but just...
No, I think it's helpful to just demonstrate that, like, as your business grows, this isn't a set it and forget it type of thing, right? You have to constantly be checking in with your legal counsel or have a legal counsel or something so that, they're really a partner with you as your business grows because the laws change, but then, just every year things change, but also the laws change based on your circumstances. So I think this was really helpful to highlight that.
Yeah, I think it's helpful to think of it as there are triggers along the way that trigger new obligations. And so just to know that as you grow, different obligations will be triggered and keep that in mind. And a lot of my clients will check in with me when they're about to hit 50 because they know that 50 is kind of a magic number where a lot of things change and a lot of new obligations come on board. But for most companies, that's several years down the line that they hit 50. And by that point, they usually have some kind of HR function in-house. They're already working with some kind of HR counseling service, or they already have legal counsel that's conferring with them on employment stuff. Because most companies have employment issues arise before they hit 50.
Yeah.
Unfortunately.
Yeah. Just the nature of dealing with human beings, right?
Exactly. We're very colorful. Yes.
I like that. We're very colorful.
Yes.
Okay. So we were figuring out these workplace postings that we either have to put in our workplace or distribute to our employees as part of an employee handbook. What's next?
Exactly. So what's next before you hire anyone is you're going to find and hire a reputable payroll company, assuming that your company doesn't have its own in-house accounting function, which I'm guessing none of the listeners will have because...
Yeah, I think most people, I don't know, like their moms are their bookkeeper, or maybe they work with a bookkeeping service, but they don't have departments here. No accounting department.
And even some of my really big clients, they outsource this stuff. A lot of people use ADP for their payroll. And a lot of startups like to use the companies like TriNet that offer, in addition to payroll services, or Zerto is another good one. In addition to payroll services, they offer HR services, what they call PEO services, where they can give you template policies and guidance on certain HR matters. So it's kind of a global services bundle. I always caution people not to let the PEO become their employment lawyer because they're not lawyers. I mean, they may have lawyers on staff, but it's not the same as getting legal advice from a lawyer. So, I think that's a separate issue. The really important thing is that you have a really good payroll company because they're going to know a lot of the intricate things that you don't want to have to figure out. Like California has really strict laws about exactly what has to appear on every employee's pay stub. If any of it is missing, it can make you liable for tons of penalties. I mean, you can have a class action lawsuit because you didn't have your company's
address.
Exactly. You need to always have the balance of an employee's paid sick leave has to show up on the pay stub. All these minute requirements, and the payroll companies know them like the back of their hands. So they take care of that. Assuming they're good at what they do. And it is a good idea to kind of periodically check in and make sure everything looks like it's as it's supposed to be. But if you're going with a really reputable company who's been around and who services a lot of clients, you can kind of stop worrying about that. And so getting them on board before you ever have to write anyone a paycheck, that's a really important step.
Now, what about, does a service like ADP, like the whole in California, like the wage and hour and when you have to give people breaks and when you have to do that, is that something that you can lean on a service like ADP to help advise you, or that's something that you should talk to a lawyer about?
So the payroll providers that also provide like HR advising benefits, they can help with that stuff. As I said, I'm not 100% comfortable with it all the time. Mm-hmm. I think that a brief conversation with an employment lawyer is usually helpful. It really depends if you're bringing on exempt or non-exempt employees. And most people are not making non-exempt hires in their first few hires.
Can we just take a step back for people who don't know the difference of what an exempt and non-exempt? Let's just dial it back a little bit and explain that.
This is the language I speak 24/7.
Oh, yeah. No, don't worry about it. No, don't worry about it at all. It's just, sometimes it's like there's so much, and so exempt, non-exempt. And let's explain that. And then my follow-up question to that is, at what point are you making that determination as a business owner if this person is exempt or non-exempt?
Sure. Yeah, that's a great question. So an exempt employee is one who is not covered, and this is a really crude basic definition, but it's one who is not covered by the wage and hour laws, such as overtime, meal breaks, rest breaks, the stuff that applies to employees who clock in and clock out and are getting paid by the hour. So if you're exempt, you could work 100 hours a week. You are not getting overtime. You are not entitled to a lunch break or a rest break. And I know plenty of people who work schedules like that. In order to be exempt, because most companies want their employees to be exempt, right? They don't want to have to worry about overtime. They don't want to have to keep track of meal breaks, because California has made it so that it's not just giving them a meal break. It's when you give the meal break. It's all these requirements. You can only classify someone as exempt if they fall under certain exemption categories. So professionals are exempt, and that's someone who went on and got a specialized degree, like a doctor, a lawyer. There are some exceptions, but we won't go into that because they're not going to apply to your listeners, I don't think. There's a computer professional exemption, which applies to certain types of people who work on computers all day, which a lot of tech companies utilize that exemption when it applies. There's an executive exemption for people who are basically bosses and are managing lots of people. And there's an administrative exemption, which used to be the catch-all. And people used to just say, well, this person is administrative. They fall into that exemption. We're going to call them exempt. And that's a place where the government is really cracking down, because really that administrative exemption shouldn't fit in as many cases as people want it to. It really needs to specifically cover someone who is kind of directing the business, is doing something, not the day-to-day work of the business, but sort of the overall strategy of the business, and really working independently, exercising their discretion, doing things that require really specialized knowledge. I won't get into the weeds on it, but suffice it to say, those are sort of the general ways that you can say someone is exempt. Anyone who doesn't fall into those categories, oh, and by the way, you also have to pay them a minimum amount of money to get them into that exempt category. But the good news is that minimum is so low compared to our California cost of living, that is really not an issue. And the U.S. government, the federal government, tried to bump that minimum up, almost doubling it toward the end of the Obama administration. And that got halted in a court in Texas. And I don't think we're going to see that coming into play anytime soon. So the salary cap is still pretty low. I think it's in the 40s. So everybody else is non-exempt. And that means that you do have to track every minute that they work. You have to track their meal breaks. You have to make sure that their meal breaks happen at a certain time during their shift. They can't work 7 days consecutively without a break unless one of the days they worked fewer than 4 hours. I mean, all this stuff that I'm sure is making your head spin and making the listeners' head spin. But, it's only an issue when you've got these non-exempt employees. And as soon as you do have non-exempt employees, you really do, I think, need to consult with an employment attorney and make sure you know what all the rules are that you need to comply with.
Yeah. So I work with a lot of folks in the events industry. So wedding planners, event planners who hire assistants on the day of, for instance, to come and help set up a wedding or design a wedding. So it sounds like, again, being very general here without knowing people's specifics, but it sounds like these people are probably going to fall in a non-exempt category, which means that they are then going to have to comply with these rest breaks and meal breaks and things like that. So you can't you probably, at least under California law, you can't be working 10 hours straight without giving people a meal or rest break, for example, right? So is that fair to assume? Okay.
As long as they are really an employee and not a contractor, like in the example you just said, maybe that person who comes in to set up for the event is just a contractor that they use once in a while. But if it's someone that comes and sets up for them every time, that's going to be an employee and most likely a non-exempt employee. And so, if they're going to work 10 hours on an event, they need to make sure that, in California, overtime kicks in after 8 hours in one day or after 40 hours in 1 week. Under federal law, it's just after 40 hours in 1 week. Mm-hmm. So, they could work 10 hours for 3 days in a row and not be entitled to overtime. And there are some more overtime requirements, if they work 7 days in a row or they work more than 12 hours in a day, you actually get into double time. They make double their rate after 12 hours in a day. But that is right. Yeah. And to your question about, when do you make that determination? You make that determination before you hire them.
Okay.
So, before you make that first hire, you sit down and you think, what is this position that I need to fill? And you should, for your own purposes, have a detailed job description for that person. You should know what their responsibilities are, what their duties are going to be, how much time you want them to be working, what background you want them to have, as much detail as you can possibly supply. And that will inform then the decision about whether they're exempt or non-exempt. I really do recommend consulting with an employment lawyer if it's not cut and dry. If you just started your own law firm and you're hiring a lawyer, that person's going to be exempt because they're a lawyer. So you don't have to go through that whole exercise. But maybe you're starting a company selling T-shirts and you're going to hire someone to come up with T-shirt designs with you. And that might be a gray area. And so you want to use the sounding board of an attorney. And I know that sounds like it would be an expensive thing to do, but usually these are conversations that can be had relatively quickly. You're probably only going to spend a couple of $100s talking about, at the most, I think talking about what this position is going to be. And it could save you a lot of money down the line, because if you do misclassify someone, that can get you into a lot of trouble, both from a tax perspective and also from a labor law perspective.
Yeah. So let's talk about that a little bit. And this isn't really to scare people, but my question was, well, what are the consequences if I'm not, if I'm an employer and I'm not giving people meal breaks, or I'm not, and it's, again, completely innocent. I didn't know. Right? Because again, most of the people I talk to are really trying to do the right thing. It's just, they have so much to juggle, right? As a small business owner. So what are some of the consequences if we're not doing what we're supposed to be doing?
Sure. Yeah. And honestly, this stuff is not intuitive, and I live and breathe it, but most people have no idea. And why would you? Why would you know exactly when someone's supposed to take their lunch? And honestly, the other piece is that it's constantly shifting. This whole requirement that meals be taken by no later than the beginning of the 6th hour, that came out of a lawsuit filed by some servers at Chili's or some other chain restaurant within the last decade.
It's so complicated. It makes me just want to go take a nap. Okay.
So, the consequences, unfortunately, are multifold, because you're looking at violations of the California Labor Code. The California Labor Code is the set of laws that requires that people get the meal breaks, the rest breaks. It includes overtime, all that stuff. And most sections of the Labor Code have a built-in penalty, and it might be $100 a day for every day of this violation. For meal periods, for example, for every missed meal period, you have to pay them for that hour, but also pay them an extra hour of time, which is a meal period premium. I've created charts for clients to look at to kind of break this down by code section and by penalty and by potential damages, which are something else that a court might pile on top. It's really complicated how many different ways you can screw this up. And the real kicker is that when you violate a labor code provision, you're going to be liable for the other person's attorney's fees as well, because that's baked into the labor code. Mm-hmm. So, these types of lawsuits, which we call wage and hour lawsuits, which often get brought as class actions because a whole bunch of people band together, which isn't a worry when you have 2 employees, but eventually you're going to have more than that. They're really expensive. I mean, massively, massively expensive. The settlements are usually in the 7 figures.
Yeah, I remember being at the law firm and seeing these come in. I did a little bit of employment work when I was at the law firm.
And you may think, well, my employees don't know or care about this stuff. And that's true. But what will happen is someone will get fired for a totally legitimate reason. They'll be super pissed off, and they'll go to an employment lawyer and say, I want to sue for wrongful termination or discrimination or whatever. And the lawyer will look at the case and say, well, you don't have anything there, but tell me about your meal periods. Oh, you say you're exempt? Really? Tell me about your job duties. And so the plaintiff's lawyers are really keyed in to what to look for. They know exactly which records to ask to see, and the courts have pretty much decided that they can see all those time records and personnel records about this stuff. So if you have vulnerabilities, all it takes is one angry employee to bring the wolves to the door, pretty much. The best practice is to just try and avoid making those mistakes from the get-go, and then you're not vulnerable there.
So, okay, yes, I like all of that. So as an employer, let's say, so how do these employees clock in? Do you recommend that they, how do you keep track of all these records? Do you recommend they use one of these services, or how does this work? Because I'm I'm thinking from the small business owner perspective, I'm so busy doing the business, right? I can't sit here and keep track of people's timesheets and meal breaks and things like that. Or is it just, I got to, because that's just part of my responsibility now?
I mean, it's a little of both, right? I mean, I do think that there are so much easier ways of doing this now that everything is online, and a lot of companies use online timekeeping where, you just click a button on your computer to start your workday. You click when you're going to clock out for lunch, and those records are automatically kind of exported to the payroll service, and it might even be provided by the payroll service. There are very few people left in the employment industry who are using physical manual time cards. It does happen, but it's not quite as precise as having people do it online. And when it comes to breaks, rest breaks, it's really hard to track that stuff because, they're paid. You're on the clock when you're taking a rest break. And so people kind of just do it whenever. Meal periods, yeah, people should be clocking in and clocking out for their meal periods. That is really important. And I've had plenty of people say to me, ugh, that's such a pain in the ass. I don't want to be Big Brother. People don't want me looking over their shoulder. Well, sorry. You do need to keep track. If they're non-exempt, they've got to get that meal period. If they say they don't want the meal period, that's fine. They don't, they have the option to not take it. However, you need to be able to prove that that was their choice and not yours.
And so how do you do that? You just get something in email, or?
There are different waiver forms that you can use. And that would be something that I would consider, there's sort of a few different forms you want to have when you get started. And meal period waivers are important if you have people who are going to be working shifts that maybe, the meal period obligation kicks in if the shift is going to be longer than 5 hours or longer. But if they're not working more than 6, they can waive it. And so, it doesn't say in the statute that they need to fill out a form, but from where I'm sitting, they need to fill out a form, because then later, when they say, look at my records, I didn't get a meal, you say, well, look at this waiver from the same date, you waived that meal.
And so you have to get it for every meal break that they want to waive, or is there a general one that you have them sign? And maybe I'm getting too into detail with this, but I'm very into how does this work? How do you actually implement these things? Because theoretically, it all sounds great. But then when you have an employee who's not taking their meal breaks, what do you do there?
Well, I'll tell you what you do there is it becomes a performance management issue, because your employees, you communicate to them what the expectation is. And if someone is not complying with your meal period policy, which you've distributed in your handbook, you've made really clear, then they get written up or they get a verbal warning, and you keep track of it. And because that person is putting your business in danger by making you technically run afoul of these laws. So that is important. It's much less important kind of how you do it, how you have people observe or not observe the laws. I mean, when you ask about the waiver, it can be per episode waiver, which is my preference. It's the lowest risk approach. But some people use a waiver that says, whenever I work X shift, I'm going to waive, but I can withdraw this waiver at any time. I mean, there's no set way to do this. So people take a lot of different paths. And the difference among the different paths is just the amount of risk. And I know that small companies tend to be more risk tolerant than large companies. So I can't say there's a right answer.
Okay.
But I don't think this is something that's going to be a hardship or a major issue until you get a more significantly sized workforce, until you're up around 15, 20, 25 non-exempt employees.
Or unless you really piss somebody off. Right?
Yeah. But then at least, if you had such a small company that you're talking about 2 non-exempt employees, the total amount of the penalties that are going to be assessed against you is going to be pretty modest. It's when it aggregates that it gets really bad. And I'm not advocating people incurring penalties. I'm just saying don't lose sleep at night over this when you're first starting out and you have 2 employees. Like, yes, talk to a lawyer, get it right, but this isn't going to shut you down when you have 2 employees.
Is there some sort of insurance outside of the workman's comp, which is obviously something different, that people should be considering when they're hiring employees?
Yeah, there's something called Employment Practices Liability Insurance, EPLI for short. And EPLI will cover most types of employment claims, but it usually doesn't cover wage and hour claims.
Okay.
Now, you can get wage and hour coverage. I think it costs a lot more. I've only had one client whose EPLI ever included it.
Okay.
So that is another reason. I mean, because they don't want to touch that stuff with a 10-foot pole. So I think it's just another reason why it's important to get that stuff right. But in terms of whether or not EPLI is a good idea, that I think depends on how much it's going to cost you and how big your workforce is and what level of risk you have. I do think it's a good idea once you start getting into double digits of employees, but that's if the price is right and you can afford it.
Now, I still want to go back to our checklist, but before we do, I just keep getting all these questions popping up that I want to make sure that we talk about. Do you think that when people are ready to hire employees, that they should be hiring people, their entity should be, an LLC or a corporation, and kind of move away from those entity structures like a sole proprietorship or a partnership where it exposes you to personal liability?
So that's actually a tax question and a corporate law question that I get to be blissfully ignorant about.
Okay then. Yeah, I mean, I generally recommend people, when you're taking on more risk, put the tax piece aside, but from the liability perspective, is start rethinking about, what is my entity structure? Does it make sense for me to move from a sole proprietorship to maybe an LLC or a corporation or whatever, where at least I have another shield of hopefully, protection against being personally liable for some of these things. Let's say if I get a disgruntled employee who wants to file a lawsuit, right? At least it's the business's assets that are, if it's an LLC or a corporation, that are at stake and not my own personal assets. But again, these are things that in the scope of this conversation, you can't come to a conclusion. These are things you need to talk to a lawyer about who can understand your specific circumstances and advise you accordingly. So, okay, I was just curious what your thoughts were, but
that brings up something important that I do want to mention, which is that if let's say that you've made your company an LLC, but you personally are the one who's being accused of something that carries personal liability with it, like sexual harassment.
Oh, yeah.
Then you're still going to be on the line.
Correct.
So there are certain claims, not a lot, but there are certain employment claims that do carry personal liability. So, those are important to be mindful of as well.
Yeah, that's a great point. And, LLCs or corporations are not 100% protection against personal liability, right? There's definitely exceptions, but yeah, that's a really great point. So hopefully nobody's doing any sexual harassment at their place of employment, engaging in that. Okay. So let's take it back to your checklist. So I think we left it off at, what was the last step? We talked about the posters. We talked about the exemption status and all that, but we've gotten all that together. What's next?
Yeah. The next step is, what you're hiring for, what that job position looks like. You've become comfortable with the wage and hour exemptions and you know how to classify people, or you've gotten advice on how to classify them. The next step is to make sure that you've got all of the forms that you need to have in place. And this is where I think a lot of small companies don't do this. And this is really this is a best practice. This isn't a legal requirement, but it's a really important best practice. And when I say forms, I'm talking about an employment application if your business is going to use something like that. A offer letter, super, super important to have a good, sturdy offer letter. You want to have an independent contractor agreement if you're going to be using those. You most likely want to have some kind of confidentiality and invention assignment agreement for employees to protect the IP that they develop when they're with you. If you're bringing candidates in, let's say you have a life sciences company and you're bringing candidates in and they might see confidential information. Maybe you need an NDA, a non-disclosure agreement. You need to figure out in your business, aside from the bread and butter kind of offer letter application type stuff, you need to figure out in your business what types of forms you're going to need for both candidates and offerees. And further down the line for employees, like, you'll need an agreement you can use when you're going to separate with someone and give them severance, and then get those forms. And you can usually get those forms if you do have a payroll provider